just have 1 second.
Okay.
Judge, as to the deposition that was conducted, we have conducted a deposition that has concluded. We received authorization for a daily copy, but all that means is that we'll get it overnight. It'll be given to us sometime either late this afternoon or tomorrow morning, is my understanding. But at the deposition, these statements, to the best of my knowledge, I'll give them to you as best I can. The question was asked of the witness, is it your opinion that your diagnosis of John has changed? The answer was no. Has your opinion changed that John committed this murder because he is a psychopath or suffers, well, I guess because he's a psychopath? No. Did he commit the murder because he is a psychopath? Yes. So, Judge, the opinion that she offered at 9:30 this morning was ruled not to be admissible by the court. She has taken the position that her opinion is still the same as it was offered at 9:30 this morning. So I would suggest that the court should not allow her to testify to that. We asked some more questions that the court may have an interest in. Would you agree that your description of John's diagnosis changed from 9:30 to 10:30? We started using those words just to differentiate between the first court appearance, then the recess, and the second court appearance. Would you agree that your description of John's diagnosis changed from 9:30 to 10:30? No. And her answer was no. I asked her if she had any access to her cell phone. She said no. She said she did not review any media, no blogs, no live feeds, had no any other electronic device. I have no reason to think that that was anything but truthful. But there we have it, Judge.
Response.
Well, I think it's clear that she is saying the same thing, but the second time she came in, she added clarification to what she meant the first time and was able to elaborate on and explain her opinion. I came back after talking to my supervisor, and we put her back on, and we fleshed out those opinions and proffered it in a way that makes sense to the court and makes sense to me. So I don't know where the court was thinking that we didn't really get a full ruling as far as what the clarification would be of what she could testify to or not. So I don't know if Your Honor was still thinking she could testify to psychopathy or not. You know, at our last break, it was clear that you were going to let her testify to her opinions. My original plan was to have her testify to psychopathy. If the court would allow that, that's still the plan. If not, she can certainly support her opinions based on the antisocial personality disorder, which is encompassed by the psychopathy. Does that make sense?
Mm-hmm.
And I would just add the reason why, I think it's obvious, but the reason why I came back in and asked the questions a different way is because we were having to flush that out. So.
If I remember her testimony correctly this morning, she said that if someone is diagnosed with a psychopathy checklist and has significantly high scores, they would automatically qualify for antisocial personality disorder and or borderline personality disorder. But the converse of that, everyone who suffers from either of those two disorders would not necessarily score high on the psychopathy scale, and I believe her testimony was that particular finding was relatively rare. Is that your memory?
Yes. I think that I think that she testified to if you have psychopathy, you also have antisocial,
Right.
and possibly borderline and some other things too.
So I don't think her diagnosis has really changed. She's just characterized it in a different manner. I think that's the common sense interpretation of what has occurred.
I understand what the court's saying, and I make this point. What we are given is a report from a doctor where they give their diagnosis. And she, I think we can admit, does not say in her report, I diagnose him with antisocial personality disorder or that I diagnose him with borderline personality disorder. She now comes in and says, well, that is my diagnosis. My problem is, how do I cross-examine someone whose report was inadmissible, that does not contain the diagnosis that she professes in the courtroom, and then say, well, my diagnosis hasn't changed. Well, it's different. We can talk about it not changing, whether, well, this or that. It is different.
I agree.
And it's so different that the court was upset by the wording of her diagnosis. Now we're letting, whether we're calling it a change in diagnosis or not, I think we're diluting the issue by doing that. She's now going to come in and testify to something different. We can all agree to that.
I agree.
The wording's different. So now I have no way to cross.
The wording is different, obviously.
The wording is different. I now have to defend Mr. Jonchuck against a diagnosis of borderline personality disorder that I did not have to defend him against this morning. And now I have to diagnose him with, I have to defend him with a diagnosis of antisocial personality disorder that was not provided to me in her report this morning. Now, I'm not suggesting that there isn't a line or a medical theory that psychopathy is a subset of antisocial personality disorder, but that's the idea of what I have to do, is defend my client against something that had not previously been told to me, something that had not previously been discussed. And that is the problem I have. In order to point out the difference in her opinion, I have to present evidence that is bad for Mr. Jonchuck, and then have to try to refute that as well.
Could I add something, Judge?
Yeah.
So, obviously our intent was to ask for questions about psychopathy, so if the court is going to allow us to do that, I don't know that I need to ask about antisocial or borderline, because that wasn't planning on doing that in the first place. We modified the questions to answer the court's questions, but more
I don't
importantly,
think they're going to. No.
The other thing I was going to add is, as far as antisocial personality disorder and borderline personality disorder, Dr. Burston diagnosed the defendant with both of those things. So that's not new to this case. Even their own experts said he had those features.
I know.
And Judge, I can tell you just a good portion of my cross is focused on the fact that psychopathy is only a specifier on antisocial personality disorder, and she had not made that diagnosis. And so the only way to effectively cross-examine her is to get in information that the court has already held as inadmissible. Like, we can't say, you testified at 10:30 this morning that he did not, you offered your opinion on his diagnosis at 10:30 this morning. It did not include bipolar or borderline personality disorder or antisocial personality disorder. You offered your opinion, the court was prepared not to let you testify. At 10:45, you offered different testimony. That is what happened. That shows bias. 100% that shows bias and motive, and we cannot even explore that without getting into all the information that the court has already said should not come in.
Judge, if I may, in the deposition they asked you, did you know about the court leaning towards that? The answer was no. I was removed from the courtroom. Did anyone talk to you about that? The answer was no. So the implication is that she knew something was going bad, or was told that something was going bad, and that she changed her testimony. That's simply not the case based on the questions in the deposition. So I think it is improper for the defense to make that allegation to the court without the supporting evidence of it, and they direct evidence against that in the deposition they just took.
And she's certainly been aware of the issue. She's been posting links on her Facebook, maybe not
I
today.
cannot.
But as far as
Don't tell
the
me what's
issues
up.
go, right. As far as the issues go, she's not unaware.
Well, I can't use what someone posts on their Facebook, obviously.
So if they want to cross-examine her as to bias, they can do that. No one's foreclosing that. I don't understand why that has anything to do with what we're talking about in terms of the opinion that she wants to give and that she offers to the jury. I don't see why that has anything to do with it.
Do you want another issue yet or no?
So what are you asking me to do? To exclude her testimony?
I'm asking to exclude the, sorry, go.
Yes, because,
But you don't have to tell me because, I know why.
okay.
I know why.
And I do have those other cases if you want.
Are they relevant to this issue?
I think they are relevant to an additional issue on the same issue, but we haven't gotten into that yet. So much regarding the comments on credibility, essentially that everything she would testify to is basically saying that John lied about this because I believe the version from this witness. So it does talk about witnesses.
Well, we're not there yet, so.
Just commenting on the credibility.
All right.
Could I also just add one more thing, Judge, since they're talking about credibility and bias? You know, I took that break so I could gather my thoughts, talk to somebody else, come back and ask the same questions of the witness. Had I been prepared with those questions right off the bat, there wouldn't have even been a break. So for them to argue bias, that doesn't really make sense because I could have just as easily asked those questions right there without a break. I needed the moment to rethink how I would approach those questions based on the court's concern. So the fact that there was or wasn't a break, when it's clear we didn't talk to her during the break, I think is irrelevant. I think that it should all be considered as one testimony. The fact that I need a break to rethink my questions to proffer her is not a comment on her or her testimony when it's clear from the evidence she didn't talk to us during the break or do anything else. She just answered my questions when she was called to the stand to answer this question.
Would you agree with me that her diagnosis has changed?
No. I think
Why not?
I think that her diagnosis is still psychopathy. But I think that what she has offered is an explanation of the fact that antisocial personality disorder and borderline personality disorder are subsumed in psychopathy. That's still her explanation for why there was an apparent change in testimony, which I don't believe was a change in testimony. That's what she said at deposition. Mr. Williams just said it's still her opinion that he committed the murder because of psychopathy. Psychopathy is still her primary diagnosis or criteria that she relied on, or clinical concern, I think is how it's actually phrased. So her opinion is still the same. Antisocial personality and borderline personality disorders are subsumed in that diagnosis of psychopathy. That's what she said, and psychopathy is still her diagnosis. So what we were offering to the court was another way to get there through her testimony, and an additional area of relevance. But I think that her testimony is the same. I don't think it's a different diagnosis at all.
Well, I think she elaborated on her diagnosis. Obviously, to me, the change would allow her to testify. I agree to that, because I was not going to let her testify if all she was going to say is the defendant's a psychopath. I was not going to do that. So, hold on. So now she's, or words similar to that. I mean, I think my decision on that was correct. Mr. Bowen, I understand where you're going with it, but do you disagree with the fact that it would have been legally inappropriate for her to testify that he didn't suffer from a mental disease, defect, or infirmity because he was a psychopath, and therefore that's why he committed these crimes?
Just a moment.
Yes. You don't have to answer.
I understand the court's thinking on that. I understand your thinking and your concerns. I think we made our arguments.
Okay.
As far as that's concerned, that one issue. For us, psychopathy is a mental health issue. It's the alternative explanation to the murder. It's the rebuttal to what they're presenting as a mental illness through schizophrenia or bipolar disorder, psychosis not otherwise specified, but schizoaffective disorder. But I'm understanding what you're saying, Your Honor.
And we would not be faced with this same issue if she had said, Dr. Lazaro, all along, that she doesn't believe that he's NGRI, he suffers from antisocial personality, borderline personality, and she used the psychopathy checklist, just as Dr. Burston did, to support her diagnosis. Right? We'd be in a different spot.
Correct, which we were with Burston, and we had no objection to that. We were placed on notice. I knew what I had to defend Mr. Jonchuck against as far as Dr. Burston's testimony was. I cannot promise the court, but I think I'm accurate, that I did not see the word borderline in her report
Okay.
or her prior depo.
I don't doubt
So it's mid-trial, mid-rebuttal that I am now required to defend my client against an opinion and a diagnosis not previously presented. That's the prejudice that we suffer.
Okay, so you anticipated that when, as she testified to initially, she didn't have a mental disease, defect, or infirmity, that he was a psychopath, for lack of a better word, you know how much I dislike that word, but anyway, he's a psychopath, then you would have had a legal position, I imagine, that that could not be used to rebut a NGRI, correct?
Correct.
And you would hopefully prevail.
Correct.
And then what was your plan if you didn't?
Well, the plan would have been that the only thing we had to get to defend him against is this narrow, yet we believe prejudicial, opinion that he's a psychopath. And as I recall her words, cold-blooded psychopath.
Well, we're not doing, I shouldn't even use it. That's already been predetermined, but my question to you is, and I don't know that you have to answer it, I guess you really don't have to, but how would you, what would have been the crux of your defense if I had ruled, yes, I'm going to let her testify to that? Not that, I'm just going to let her testify that he's not mentally ill because I did this psychopathy checklist and this is what it is. Not cold-blooded killer or psychopath, but this is what it is. This is what drove him. This list of traits.
Well, then I would have had two choices.
And I'm sure she would have tied it into the mental illness somehow.
Right, and I'd had done that, I'd have had two choices. One, allowing me to speak, I would have said, look at the quality of my witnesses and the quality of their opinion versus the quality of this outlier's opinion. And I might not, and that might have been all I would have done. Or I could have also decided, all right, her report is so extreme, so over the top, so any other word you want to use, that I would then have had to decide, okay, do I go with just that? Or do I go ahead and attack this witness on the basis of her report? That she says things like cold-blooded psychopath. That she says things like the victim experienced the worst nightmare she could have had, being thrown over the bridge into the cold, frigid waters, thereby, that's a legitimate way to cross-examine an expert witness.
I understand that.
And I might have done that, but I might not have, because I also have another, but I'm fortunately having to choose now in the midst of the trial.
But how does it change, really?
Way. It requires that in order to do that successfully, if I make that a feature, then I have to be certain that I'm going to be able to get into every instance of bias and every instance of prejudice, and that requires the ability to know that's what I'm doing ahead of time. In other words, I should be allowed, I should have an opportunity to know what my cross-examination is, arguably before the trial begins, and certainly well before we're halfway through the road. We might, in other words, I might have had my experts testify ahead of time to lay the foundation for, is it appropriate for an expert to say something like this? Is this diagnosis even something that an expert would consider, could consider, should consider? These are all things that I could have done before she testified, which then would have allowed me still both of those opportunities on cross-examination.
That's a pretty good argument.
Well, Judge, I want to get back to the point that antisocial personality, borderline personality are all elements of psychopathy.
So if they know about psychopathy, they know about all these other elements. So when I questioned Dr. Lazaro about the elements that she described for antisocial personality disorder, they're very much the same type of elements. So I don't see how they're surprised or not prepared for what we were going to do.
But she also said that just because you suffer from those mental illnesses doesn't mean that you have psychopathy features, and that it is rare that she diagnoses somebody as with psychopathy features, and that's just what they're all about.
Right.
Which basically, I mean, we all know that sociopaths are, what, 2% of the population, supposedly?
Right, but Mr. Williams is saying that they're unprepared for this cross-examination, and I don't see how that could be, because they already know that the traits that she's testifying to or was going to testify to, which includes psychopathy, include many if not, actually, I think based on testimony of Dr. Lazaro, include all of the same features of antisocial personality disorder. So I don't know how they're disadvantaged in not being prepared to cross her on those issues.
Well, what about his point that their experts, when they testify, were not aware of this, whether you call it a change or whether you call it an elaboration or whatever you want to call it? How do you...
Well, Dr. Burston testified that psychopathy is the most extreme variant of antisocial personality disorder. He said that you have to have antisocial personality disorder to get the psychopathy. I believe he probably said that in a hearing that we did prior to the
but
trial.
what about their experts?
So their experts would have known that information. That's information available to their experts since before the trial.
Well, what about their experts, though, calling them and saying, hey, expert, Dr. Lazaro now says, kind of, sort of, that he suffers from antisocial personality and disorder. I don't know about the borderline. And the only reason she didn't say it before is because the psychopathy was so overwhelming. For whatever reason, she didn't characterize him with the other disorder.
They could have
I think they'd be asking him, isn't that weird, or why would that be, or is there any validity to that?
Well, they could have asked their experts before that. They could have asked Dr. Lazaro prior to today. They could have asked for that in deposition. We did 2 full days of deposition with Dr. Lazaro. Clearly, they're on notice that psychopathy comes from antisocial personality disorder because Dr. Burston has been saying that from the very beginning. So that's not new information. They could have always asked their experts about that. They could have asked Dr. Lazaro about that. I don't think that that's new information. I would also point out that, you know, I don't know how much the court would allow me to get into this, but their expert, Dr. Mackless, said in his testimony that his diagnosis of bipolar, which he had in his report, which he had in his deposition, he said for the very first time that I'm aware of on the stand, well, it could really be any of the other diagnoses too, because of the mood disorder. He said, and they asked him, and he knew the answer right away, that because of the mood disorder, it could be any one of the other 3. That was the first time we heard that.
I'm going to take a brief. We're going to say something else.
Just one more thing. I think that, and because of that question that they asked Dr. Mackless,
Well, I can't say it's the reason why, but I suspect they also asked, I think, him and maybe some other experts, can diagnoses change? And I think they had one or more of their experts say diagnoses
Oh, of course,
can
I think
change.
everybody said that.
So, again, I don't see the prejudice when they're already aware of all of this information, in this case through Dr. Burston, through all the other evidence in the case.
Okay, I'm gonna, talk to some other brains. It won't take me long. Do you have anything else you wanna say?
I have one more factual thing and then
I don't mean other brains, like,
I know what you mean.
Yes, I wasn't suggesting. What are you doing?
I know what you mean.
Okay.
I have one more factual thing to add, and then I think Mr. Williams has one more point on the argument.
Okay.
Just for clarification, we keep saying that psychopathy is a specifier for antisocial personality and borderline personality. It is not. It is not a specifier in borderline personality disorder. It is nowhere else in this book. Dr. Burston testified the same. So that is, it is a bit of a difference because now we have, it's not one that because it is a specifier for borderline personality, we should assume that she encompassed that in. It is not listed at all under
Okay.
borderline personality.
All right, got it. What else?
Only these two things, Judge. In this morning's deposition, we asked, in depo, did you answer questions regarding whether the defendant displayed or had a diagnosis of borderline personality disorder? She says, no, you didn't ask me questions about it. We didn't because it wasn't in her report. So there's
Okay.
that issue, but there's another issue, and that
I don't
is,
think it's incumbent upon you to have discovered this.
and the second issue is that her testimony previously, to put it in the words of their expert and our experts, you put us all in the same room, we're all pretty much going to have the same diagnosis. Burston, I think Mayor said that and Burston adopted that. And that was all right, because I had Dr. Lazaro in a whole separate room I didn't need to do anything because she's just way out here. Now, not only is she no longer way out there, she's trying to get in the room with him, and she's now bolstering or offering opinion that's consistent with their expert who testified yesterday, and she's offering that opinion or that diagnosis that she had not previously offered.
She's still out of the room. Dr. Burston agrees that Mr. Jonchuck is severely mentally ill. I don't see really any similarity in what I understand their positions to be. When I listened to Dr. Burston's testimony, I thought it enhanced his credibility in that, to me, there's a certain uncertainty about it. That's what I took away, in part, and I know what his opinion is. But I certainly don't think that Dr. Lazaro will be in the same room. So, but I don't think it matters, that's not the issue. Okay, so give me 10 minutes.
All rise. We'll be in recess for 10 minutes according to the courtroom clock. You may be seated.
for this. Deputy Rice, do you want to tell us what?
Your Honor, we may need Mr. Jonchuck.
Oh, let's bring in Mr. Jonchuck, please. Okay, Deputy Rice, do you want to tell us what 2042 told you?
Yes, Your Honor. Jury number 12, as he sits in the box, as I was escorting him back to the jury suite, he informed me that he had overheard a conversation by two gentlemen in the cafe during his lunch break. He perceived them to be attorneys, as by the way they were dressed in suits. He said that he'd overheard them making disparaging comments about Your Honor, particularly her appearance, as well as then he made disparaging comments regarding the defendant. He said he immediately got up and removed himself and stepped away.
And obviously you didn't ask him what the disparaging comments about
I
the
did not.
were. Okay.
I informed him that, he asked me, was that something that he should have told me? I said, absolutely, and it would be brought to the attention to the court.
So I would think I would bring in 2042, start there. Okay, let's bring him in, please.
Would the court mind in doing all the inquiries of the juror?
Pardon?
If we have follow-up questions, I guess maybe we could approach and the court could pose all questions?
No.
Okay.
Just have him stand right there at the edge of the aisle.
You can sit down.
Please, have a seat.
Good afternoon, Juror 2042.
Thank you.
You absolutely did the right thing in communicating with Deputy Rice, absolutely, and I'm very thankful that you did. Can you tell me what you heard in the coffee shop?
Down in the cafeteria. I just had my lunch today, which is rare. I sat down and there's two lawyers. They were many tables away from me, dressed up in nice suits, and they had carrying things. So they're professional, and they made jokes about your appearance and Mr. Jonchuck's name.
And Mr. Jonchuck what?
His last name.
But just his last name,
Correct.
nothing more than that.
No, well, I heard that, and I sort of heard that, and I just got up and walked away.
Okay.
It was very unprofessional. I couldn't believe that those people would say something.
Just any of the things that you overheard?
No, it was very minimum. I walked away real quick.
But that's not going to impact in any way?
No, not at all. It just was very, I was shocked how unprofessional it was from those guys.
Okay, thank you very much.
Okay.
And obviously, you didn't tell anyone else? In the jury room?
Well, I told one lady that was in there, I think exactly what happened.
Who did you tell? Where is she sitting?
Number one.
Number one?
Yeah, but I just said exactly what happened.
Okay, thank you. So that wouldn't seem to be a problem?
I was going to ask the court to inquire on what, if he made any assumptions about if those people worked for either our office or the state's office. He characterized them as very unprofessional, so if there's no assumptions, that's great. If he is assuming they're for one of the other offices, then
Well, he said it wouldn't affect him. I don't think I need to ask him if he thinks about where they were.
but then he added the extra, but it was very unprofessional.
Okay, let's have him back in.
If you're right, go ahead and bring that.
Could we also maybe let him know not to discuss it with any of the other jurors?
Or explain to another private attorney, so they're not to assume it's either office.
Yes.
Mr. Emsley, do you have any idea where these lawyers work?
No, I don't. I don't even know if I saw them again, but they had very nice suits on, and they were wheeling their bags.
Okay. And please don't discuss it with anybody else, okay? Thank you very much. Okay. I think we're ready, right?
What about the juror he spoke to?
I told him, I don't. Do you want me to have her in too?
I think that would probably be a good idea.
Okay, let's have Ms. Urizarian, please. Juror 2247.
Jocelyn, Deputy Rice.
If they had really nice suits, they didn't work for either one of our offices.
Yeah.
We can't afford that.
I was like, well, then, we know we're in the clear, guys.
Copy.
Okay, hello, got a couple questions for you. My understanding is juror number 2042, who I think you know who I'm talking about, had a conversation with you about something he heard in the coffee shop.
Correct.
Can you tell me what you remember about what juror number 2042 said?
He pointed out two individuals that had suits on, looked like lawyers, sorry. And he said they were making comments about the judge and her hair. And they were also making some comments about this particular case, and he got up and walked away. That's what he told me. And I just responded and told him, you should have told him to shut the fuck up. Sorry. That's what I told him. And then I said, I'm originally from New York. I certainly would have gotten up and said that to him.
Okay. And he didn't tell you what comments about Mr. Jonchuck?
He said they were making a rhyme.
A rhyme?
A rhyme.
Okay. Do you know where these lawyers worked?
I have no idea.
Is there anything about that discussion that you had with juror 2042 or looking at these lawyers who we pointed out that would have any impact whatsoever on your decision making in this case?
No.
Okay. And you won't tell the other jurors about it? Have you told any so far?
Well, they asked, and I said he heard some lawyer saying something, and he commented to me. That was about it.
Okay, in the jury room kind of?
Yeah.
Was it? Okay. Thank you. We'll be with you soon.
Okay.
You don't want me to have all the jurors in, do you, and ask them?
Well, my concern is that somebody said something randomly in the juror room, like, oh, he heard something, which then triggered somebody else to say, oh, yeah, I actually heard something too, or...
Well, she said that she told them all. Not the contents of it, but just, you know, hey, these two lawyers down in the cafeteria. I mean, she said that.
Right.
Okay, so you want me to individually, can I do it as, I know I can make the decision. Can I do it as a group, the remaining ones?
Yeah, we're fine.
Okay, let's bring in everybody except, well, bring in everybody, please.
Deputy Rice. Go ahead and line them up and bring them all in.
It's only 1:30.
Jury's in the jury box and seated, John.
Welcome back. I have one question for you, maybe it'll be two. Juror 2247, sitting right there, and juror 2042 had an interesting happening over lunch, and I believe that it might have been mentioned in generalities in the jury room. Does everyone know what I am talking about? Yes?
Yes.
Is there anybody who does not know what I'm talking about? No, okay. Would the information that they might have briefly relayed to you affect anybody's ability to sit here and be fair and impartial in this case, in the minutest way? No. No. Okay. Counsel, approach, please.
said that's the way between them started. One of them is sons and grandsons. Study, I think there's another three, just using 6 of them. I count. 3 were executed. And 1 died in captivity. So, Cole, Dick Cole was the last survivor. He wasn't one of them. But he was one of the older ones. He doing his cool. What an honor than sitting next to him and being the first one off. So, yeah. Kind of sad, but at the same time. Oh, basically knowing you were coming, possibly coming back. You always have that hope at the same time. You know. But it's there's a lot of pictures. Like I said, on one website, you just type in Google Layers. There's a lot of pictures, and they actually have a photo of the goblet. And you look at them. They're not very big. I've seen them. But it's interesting. When you see them, you see so many of them upside down. You can still read the name. Then they'd have a private, like I say, a private toast every year to those that passed on.
Call your next witness.
State calls Dr. Emily Lazaro.
Would stand here. Clerk, raise your right hand. Prayer to take the oath.
Do you solemnly swear to affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
We'll have a seat in that chair, speaking loud and clear voice for the court. Move up close to the mic.
Good afternoon, Doctor.
Good afternoon.
Good afternoon.
Would you please state your name?
Emily E. Lazaro, MD.
And how do you spell your last name for the record?
L-A-Z as in zebra, A-R-O-U.
What is your occupation?
I'm a psychiatrist.
All right. And are you specifically a forensic psychiatrist?
Yes, I'm a general and forensic psychiatrist.
What is forensic psychiatry?
Forensic psychiatry is the study of the interaction between the law and psychiatry.
And how is that different from forensic psychology?
Psychiatrists are physicians, medical doctors. That's the primary difference.
Can you describe to the jury your education?
I got my undergrad degree from Baylor University in Waco, Texas, and then I went on to do my master's degree at Texas A&M in College Station. And then I did my medical school at the University of Texas Health Science Center in San Antonio. And then I went on to do my residency training here at the University of South Florida Department of Psychiatry, where that's a 4-year residency program. And in the final year, I was the chief resident over all the psychiatrists. And then I have a fellowship in forensic psychiatry from the University of South Florida. I was the first fellow to graduate from there.
And what year did you obtain your medical degree?
2002.
What licenses do you hold?
I have a medical license in Florida, Texas, Mississippi, and Illinois, and I'm also a registered dietitian in Texas.
Do you have any professional memberships?
Yes, I'm a member of the American Academy of Psychiatry and the Law, and I'm also a member of the Florida Medical Association.
Can you briefly describe to the jury your employment experience after becoming a physician?
I've been in private practice since 2008. Prior to that, I've done various different moonlighting opportunities in my residency program. So I was a psychiatrist at the Bay Pines VA and the Tampa VA hospital. I also was a chief compensation and pension evaluator at the VA hospital. And then I also have done a lot of work in corrections. I have been the chief psychiatrist in multiple different units in different correctional facilities. Rayford, which is a prison, and there's a lot of mental health issues there. I've worked on death row, I've worked in jail, multiple different jails. I've also been chief psychiatrist in a state forensic hospital in Texas, in Vernon, Texas, where I was treating patients either not competent to proceed or not guilty by reason of insanity. I also ran a not guilty by reason of insanity clinic in San Antonio, Texas for many years.
Have you had the occasion to teach at USF?
Oh yes, I teach the medical students psychiatry, and I also teach the residents psychiatry. I've taken on some students that want me to mentor them, and that's a little less formal, but I teach mostly. I also teach at another company called Health Integrated, where I teach about just different medical psychiatric issues to teach their staff on how to assess and make sure the medical treatment is the appropriate medical treatment for them.
Have you published any articles?
Yes, I have. I've published a couple case studies, and then I published an article on a forensic case. Do you want me to say what that is, or just I have published articles?
Okay. And how about presentations? Have you done any presentations in your career?
Yes, I do a lot of presentations. It's part of my teaching. I do a lot of different presentations. I don't know how many I've done, over 100.
What kind of presentations?
They're over different psychiatric aspects, and I've done different things in forensics. I teach in forensics at the university, and I've done personality disorders. It's another one of my things that I like. Different anxiety disorders, post-traumatic stress disorder, different medical psychiatric disorders. I really like medical psychiatric stuff, so that's one of the things that I teach on.
Have you ever testified in court before?
Yes.
How many times? Approximately.
Approximately 70.
And where at in Florida have you testified?
Here, I'm very bad at geography. So Hillsborough County, Citrus County, that's the primary ones that I can
Central Florida primarily?
Yes.
And have you ever been hired by state attorney's office before in the
Yes.
state of Florida?
Yes.
Have you been hired by defense attorneys?
Yes.
Were you recently hired by the public defender's office in this circuit for a case?
Objection, relevance.
Yes.
When was that?
Testifying or being retained?
Retained.
Can't say. I can't say when I was last retained from here.
Let me ask a different question. When is the last time you testified on behalf of the public defender's office for the 6th Circuit?
In January of this year.
January of this year.
Yep.
Have you ever been hired by the state to conduct an insanity evaluation, like in this case, and found that the person was actually insane?
Yes.
When was that?
The last time it was, I believe, August of last year.
Have you ever testified on the opposite side of Dr. Burston before?
Oh, yes.
Objection, improper bolstering. Oral.
You can answer.
Yes, I have.
Who hired you in this case? In this case?
You.
On behalf of the state attorney's office, right?
Yes.
And when was that?
I was retained in this case March 28th, 2017.
Okay. And what were you asked to do?
I was asked to evaluate Mr. Jonchuck to determine whether or not he meets the criteria for not guilty by reason of insanity.
And what is a forensic psychiatric evaluation? How would you define that?
What it is an evaluation of somebody's mental state. It depends upon if you're looking, whatever question you're looking at. You could be looking at different things like competency, or just trying to figure out what's going on with them now. I don't know if you want me to go through the procedure.
Well, how do you approach it when you approach a forensic psychiatric evaluation?
What I do is I usually get documents. I'll be called by the attorney, and they will let me know what the case is, and then they'll send me some documents. I like them in paper format, and so they send them to me in a paper. That along with whatever else. So they might send me audio files or something like that. Then I review the material that I've received, and then usually from there I have additional questions, and I might ask them for more material, and they might keep giving me more material also, just depending upon when it comes in. So once I do that, I then schedule an evaluation with the person that I'm going to evaluate. And once I do that, I go and talk to them. And depending upon the situation, it might take 1 or 2 or 3 or 4 interviews, depending upon how cooperative the person is, or what other questions I have, or if there's new material that comes about, or just whatever various things that happen. And then I go home and I ask whoever's retaining me, do they want a report? If they tell me they do, I usually just sleep on it. That's one of the things that I do, try to come up with what's going on, just get everything in order, and then I start writing the report.
So are the records that you reviewed sometimes called collateral data?
Yes, they are called collateral data.
Okay, that's how you refer to it in your profession, correct?
Yes.
So can you just briefly and very generally describe to the jury the types of collateral data that you reviewed in this case?
Yes. I reviewed the police reports. I reviewed autopsy. I reviewed different mental health records, jail records from the jail, and then records from the state hospital in this particular case. I've also reviewed a lot of audio and video. So I received the interrogation video. I received multiple other different videos, and then some audio calls. I got the autopsy pictures, the photos, and police reports. In this particular case, there's a lot of Department of Children and Family reports. So I got those. I also got school reports, school records, different evaluations from the different experts, depositions from all the different people that have been involved in the case.
So let me ask you another question.
Yes.
You mentioned a forensic interview. What is a forensic interview? How is that different from any other interview that someone might conduct on the street?
Well, forensic interview is a little different because there's a specific question there. Number one, there's a specific legal question. Number two, it depends. Sometimes I'm hired confidentially and sometimes I'm not. So sometimes the information is going to be disclosed and sometimes it's not. So that's another different aspect. Another aspect, and I think one of the primary aspects that are different from this type of evaluation, from just seeing a patient in my office, is because in this evaluation I have a lot of information around the person rather than just seeing the person and taking what they say at face value. So that's the biggest difference, because when you're in a clinical practice, you might just see the person. You might not get any information outside of them. At times, if I know that they've seen another provider, I'll get a release and I'll get that information, but that is not common. It is not common to get the amount of records that we get in forensic cases. So I would say that's the primary difference.
And why is a forensic interview important?
Well, it's important because I need to find out what's going on and to answer a question. And so that's the primary importance. But then another aspect of it, not only am I looking for diagnosis, but I'm getting a feel for the person, what their normal interactions are like. And when you spend a lot of time with someone, even in this context, you do get an interaction with them and sort of get an idea of what's going on, or what kind of person you're talking to, the different things. You look at even sort of how they look, how, if they smell weird, if there's any body odor there, what their hair is like, if they have any movements that, is not typical. There's a lot of different things that you look at in a forensic interview that's a little bit different than otherwise. But in this particular case, that's what I'm looking at when I'm in the interview.
And did you conduct a psychiatric interview in this case?
Yes.
Of the defendant, Jonchuck Jr.?
Yes.
When was your interview?
I had a couple interviews.
Tell us the first date for the first interview.
The first day was October 24th, 2017.
Okay. What were the times that you spent with him on that day, or approximately how many hours were you with him that day?
I was with him from 8:45 in the morning, approximately to 3:45 in the afternoon. Now there was also a break in there because at that time, oh no, not that time there wasn't. At that time I was pregnant with my second set of twins, so did not take a break at that time.
Okay. When was the second evaluation or interview?
The second evaluation was May 15th, 2008, and that was from 9:20 a.m. to approximately 1:30 p.m.
And where did these take place?
They took place at the North Florida Evaluation and Treatment Center in Gainesville.
And what are collateral interviews?
Collateral interviews, they don't occur in every case, and I don't do them in every case, but in this particular case I thought was important. Collateral interviews is when you talk to other people that you know that are around this person to try to get an idea, more of a 365-degree view of what's going on with the person rather than just, again, what they're telling you or even what you're just getting in a deposition, because a lot of times, when you're getting information on a deposition or a police report, those are not psychiatrists asking those questions. Those are just regular people or a police officer, and people say different stuff to different people. So the collateral interviews I do, and it just depends upon what persons I have access to, but I can sort of tell when I go through the record sometimes who I would like to speak with, but I don't always get to speak with every person.
Did you conduct collateral interviews in this case?
Yes.
Who did you interview?
I interviewed Michelle Kerr, Phoebe's mom. I interviewed Michelle Jonchuck, John's mom. I interviewed Brian Morris, who's John's uncle. And I interviewed his childhood best friend, Melody Dishman.
Okay. Are you being paid for your time on this case by the state?
Yes.
What's the rate that you're paid at?
The state rate is $150 an hour.
Do you know how many hours you spent working on this case? Or have an estimate?
It's a lot. It's over 300 hours now.
Did you write a report in this case about your findings?
Yes.
How long is your report?
My report is 87 pages, single space, size 11 font.
Are the collateral records and collateral interviews that you considered in this case normally considered and relied on by forensic psychiatrists in your field?
Yes.
What's the legal definition of insanity that you are applying to this case?
The legal definition of insanity is that one has to suffer from a mental illness, infirmary, or defect, and due to that mental illness causes a person not to know what they did or the consequences of their actions or what that they did was wrong.
So that's the standard that you applied, correct?
Yes.
And so I'd like to focus now on your clinical examination of the defendant on 10/24/17 and May 15th, 2018. Were those face-to-face evaluations?
Yes.
And you already testified that they were at the state hospital, right?
Yes.
And when you sat down with the defendant, did you review with him the limits of confidentiality for this examination?
Yes, I always do that right at the beginning. I talk with them pretty extensively about who I am, why I'm there, and I always talk to them about the fact that I'm a medical doctor because sometimes I can't really take myself out of that role. So there's occasions when I might say, oh, you might want to look into that, or there's medical issues that maybe is going on that I can't help myself, I talk about. So I do talk all about that before I begin the interview.
And did he agree and understand and proceed with the interview?
Yes.
How would you describe his appearance during your evaluations?
I mean, he looks like he does now. I mean, but he's wearing different clothes, state hospital attire, cleanly shaven. One of the things that I did notice when I first saw him is that he was sort of flat. His expression was flat, and he was also wiping his mouth a lot. And for me, I know, just based upon my experience working with patients that are on antipsychotic medication, a lot of times that's a reaction to those medications. So I noticed that. One of the very first things I noticed when I was seeing him.
What was his behavior like during your evaluation?
The first interview was a lot better. I believe that he was more cooperative with me in the first interview. But he was answering questions, but in a guarded fashion, which is not uncommon for these interviews because it is, sort of a serious thing, and people don't want to, they do protect themselves a little bit.
How would you describe his mood?
I believe he's what we call euthymic, or just normal mood.
Okay. And his intellect, how did his intellect appear to you?
His intellect is at least average, yeah.
Okay. And how would you describe his thought processes during your interview?
I felt that his thought process was logical, coherent. He understood the questions that I was asking. Sometimes I feel that he...
Speculation.
You can answer.
I felt that there were times when he wasn't being elaborate. He has a good intellect level, and typically in these interviews, I typically gain a good rapport with somebody. And when I'm doing an interview, I try to be very open-ended with it because I want to get what their impressions are more than my impressions. But I felt that in this interview, it was a struggle for me to get open-ended questions answered. And I felt that was due to somewhat of the guardedness, and the nature of this. But then I also felt that there was maybe a little bit more there. So that was difficult for me because the interview didn't go as smoothly as it could have gone.
During your evaluations, did he ever report that he was having any auditory or visual hallucinations or delusions while you were talking to him?
No, he didn't report anything.
Okay. What does it mean to be psychotic? Can you define that for the jury?
I know you guys have heard this already a million times, so I'm going to do a little bit different. But when somebody is psychotic or suffers from a psychotic illness, they can have several different symptoms, but they have to have at least 2 symptoms of that list that you guys have seen. Hallucinations, delusions, illusions, negative thought process, and sometimes speech disturbance or disorganized speech.
Can you give us a specific example of a psychotic symptom so that the jury has a picture of what it looks like for someone to be psychotic?
Oh boy, well that's a bigger question. Just for one symptom, that's really hard to do, but I think the best kind of example I can give is a delusion, because those are more classic for schizophrenia, and it's really hard. I mean, I can give you guys an example. I mean, I wrote a case study on a patient that I had treated who had a psychotic delusion, and this psychotic delusion was so severe, and it occurred over a large period of time. I actually saw him after he did something to himself due to his psychotic delusion. Just to give you a little background, he's in his early 20s.
Objection relevant.
16.
Did the defendant appear to be psychotic during your evaluation?
No.
Okay. Why do you say that?
Because he wasn't. He didn't have any psychotic symptoms. He wasn't reporting any psychotic symptoms. He didn't appear to have any psychotic symptoms. He wasn't responding to any internal stimuli. And there was nothing about John that gave me an impression that he had any psychotic symptoms.
All right. Did he understand during your evaluation where he was and why you were there?
Yes.
Was he on medication at the time of your evaluation?
Yes, he's on a lot of different medications.
Can you tell us what he's on medication for, or what he's taking medication for?
What he's taking medication for per the state hospital?
Actually, let me rephrase that. Tell us what the medication is and what it's for, yes, per the state hospital.
Okay, so he's on multiple different psychotropic medications. One of them is a haldol-decanoate shot, which is an intramuscular shot that you're given. A lot of times patients get that because they're not compliant with oral medication. They want to make sure that they're getting the medication. Haldol is a typical antipsychotic drug, which means it's a very heavily bound drug to dopamine. Dopamine's a neurotransmitter in our brain that makes psychotic symptoms happen. So it binds to that, so that way that psychotic symptoms lessen. So he's on that. He's also on Haldol oral medication, which is the same drug, just an oral formulation. He's also on a medication called Seroquel, which is an atypical antipsychotic, which means it binds a little bit more loosely to dopamine, and it also has some serotonergic action in it. And then he's also on, I believe, clonazepam, which is a GABA agonist, a benzodiazepine. And he's also on Wellbutrin, which is an anti-anxiety, anti-depressant medication.
Did the medication appear to affect his understanding at all?
No.
All right. Did you do any testing of the defendant during your evaluation?
No.
Why not?
Because I didn't believe that any testing was needed.
Okay. And specifically, why didn't you perform any malingering tests of the defendant during your evaluation?
Well, I didn't because he wasn't malingering any symptoms that can be tested with a malingering test. So, you know, all of our malingering tests test for a certain thing. So they may test for a cognitive problem, a memory problem. They might test for whether or not somebody is faking legal knowledge. They might test for all different kinds of things. Whether or not somebody is suffering from psychotic symptoms. There's many different tests. But if a person is not reporting to you any symptoms, then you can't do a test for symptoms that they're not reporting.
During your evaluation, he was not reporting any symptoms?
No.
What does malingering mean in psychiatric terms?
Malingering means overproduction or feigning of symptoms for secondary gain. And what a secondary gain is it could be either something like external to you, so money, or to get out of the consequences of your illegal actions, different things, claiming disability, other things like that.
Is malingering found in the DSM, or Diagnostic and Statistical Manual, used by psychologists and psychiatrists?
Yes.
What's the criteria for malingering in the DSM?
The criteria for malingering is actually 4 different criteria. One of the criteria is that it has to have a medical legal context for the symptoms. Obviously, in this particular situation, it's a significant medical legal situation. The second one is compliance or non-compliance with a treatment or assessment. A third one is the symptoms that they're reporting are more than what you're observing them to be. And then the fourth one is the presence of what we call antisocial personality disorder.
And when those factors are present, is malingering something that you should look for?
Well, in any forensic evaluation, you should look for that. But yes, that's one of the things that any of these things are happening, that you should be concerned and to be looking at it as a subject of clinical concern.
Are you trained as a psychiatrist to detect malingering during your forensic interviews?
Yes.
Okay. And what does that mean? Detecting malingering.
Okay, well, detecting it, we get actually trained in that in medical school because in different contexts, people might fake symptoms for different reasons. Whether it's a medical thing, faking chest pain, or faking a slip and fall, or faking a back pain, or anything to get pain medications, or faking suicidal ideation even sometimes to get in a hospital bed because, you know, they don't have a place to stay or something like that. So we're taught those kind of things very early on, but as a psychiatrist, we're taught and talk about it a little bit more just because, you know, we get talked about it in our context. And then in forensics, we actually get trained on it even more intensely because it is much more prevalent in the job and the kind of work we do.
So when you conducted your evaluation with the defendant, did you tell him that it was important to give honest answers to you?
Yes, I say that at the beginning because for multiple different reasons. Number one, I don't want to waste my time with somebody that's not telling me the truth. I mean, it's hard for them, it's hard for me, and I just don't like it. But number two, a lot of times in these situations, have had a lot of time between whatever's happened and then when I see them. And they have a lot of time to come up with different reasons why they did what they did, and I have all this additional information, and in addition to what I'm getting from them, and I sort of tell them that in advance to sort of save face and make sure that they know that I'm going to be assessing for this, and I'm going to be able to tell if you're not telling me the truth, and it's not going to be a comfortable situation for either of us. So I do talk about that at the beginning of the interview.
And when you have that conversation, do you use the word malingering when you have that conversation, or do you phrase it differently?
Well, it depends. If I was talking to a forensic psychiatrist, yes, I would use that word. But for the most part, for the persons I evaluate, I use the term lying because that's what the average person knows it to be. So I use that term.
Did the defendant in this case fully participate in your interviews?
No, I don't believe so.
And why not?
Why don't I believe so, or why didn't?
Can we approach her?
Ladies and gentlemen, we need to have a very brief mini hearing. Shouldn't take more than 5 minutes. Yeah, I got it.
Jury's out of the hearing in court, Your Honor.
Should I ask a question or just tell her what the issue is? Question, okay. So did the defendant fully participate in your interviews? You said no.
Yes.
So my next question is, why not? And I believe you asked me, do I want to know your opinion?
Well,
What is your opinion of the defendant's response style in the interview?
I guess my question was, when you said why not, did you mean his behavior? And that's why I was saying why not, just what his behavior was, why I didn't feel like he was participating, or why do you feel like the origin of why I didn't feel like he was participating?
Let's answer both.
The behavior is that he would say, I don't know a lot, to answers that I was asking. But then he would know stuff about other things around what I was asking. So it was then difficult for me to have him complete a full story because he would say, I don't know a lot of the time. So he was not participating in that way. It was not an open interview. It was very short answers. And so it took a long time to get the answers to questions, and he wouldn't elaborate. So it was hard to get an open interview because of that. And so that's why I felt that he wasn't participating, because it was very difficult to go through the interview rather than just say, so tell me about how you were raised. And then somebody would go on and talk about that. That was not what was going on with my interview. It was a one-line answer. And then I would have to keep going and going and going and asking question after question after question to get a history.
So my follow-up question to that would be, how did that contribute to your opinion in this case?
Well, it was one of the reasons why I said that he was malingering, because he was not telling me full answers to questions that I was asking.
I think we're probably okay with that.
Yeah, let's bring him in, please.
Sorry.
You don't think otherwise, do you?
I do.
Oh, okay.
She just testified that malingering is the equivalent of lying. So then to now go on and just say that she believes he was malingering, that's what the court
I
just said she couldn't
understand.
say.
She's not saying he's a liar. Let's bring him in.
Jocelyn, Deputy Royce.
Line up, bring him in. Four. Couple in the restaurant.
He's in the jury box and see him.
Dr. Lazaro, did the defendant fully participate in your interviews?
No.
Okay. Why do you say that?
Because when he was speaking with me, when I was asking questions, typically in these interviews, I'll ask a question, a broad question like, so tell me about how you were raised. And they'll go on and talk about that for a while. And I'll just sit there and listen to what they're saying. Tell me about your psychiatric history, especially if somebody that has a psychiatric history, and let them go and answer those questions. Tell me about your medical problems, these type of things. But when I was asking John those questions, I was expecting, because he is very verbal, I was expecting him to just run with the question. It was just a one-line answer a lot of times. So it made the interview very choppy because I had to ask him every little point of a question and keep going like that, versus typically when I'm asking in an interview, they just go with it, and sometimes I even have to stop people because they're talking so much. But that was not the case in this interview.
When you looked at the collateral data, is it important And also in your interview, is it important to learn about a defendant's life history for your evaluation?
Oh, yes.
Okay. And was that important to you in this case as well?
Yes.
Why is that important to an insanity evaluation in your opinion?
Well, because you want to know how somebody's been doing over the course of their life. I mean, obviously there's a point that we're talking about, but you want to know how it evolved, and if it evolved, if there was something going on for a long period of time, or if it was just related to one period of time, what different things contributed to it. You know, you're sort of trying to get a feel for the person in general, their environment, how they interacted with the environment over the course of their lifespan. So it's very important.
Did you ask the defendant about his life history during your evaluation?
Oh, yes.
Now, as part of your evaluation, do you also have to rule out drug use on the date of the murder? Is that something that you have to consider?
Yes, you have to consider that.
All right. And did you rule out drug use on the date of the murder in this case?
I ruled it out based upon the interview.
And explain what you mean by that.
John told me that he hadn't used any drugs from about the center of December. So, and also, he said that consistently among different interviewers. So that was a similar statement that he had been making. So I had to take his word for that and say, okay, well, that's what he's telling me, so I'm going to go with that.
What did you learn about his developmental history, biologically speaking, that was significant to your insanity evaluation?
He was born a big baby. His mom did not use any drugs while she was pregnant with him. She had him via C-section. He participated, or he did all of his developmental milestones within normal limits. There wasn't anything that was significant there in terms of biologically or organically that I noted on when he was born.
And what did you learn from him about his medical history during your evaluation?
I learned from him that he has back issue. He said that he had a back issue, that he had a spinal stimulator placed. He also told me he had high blood pressure, which he's had from a young age. Now, I had known some about John already before I came into the interview, and I had known from reports that he had been seeing psychiatric treatment since he was a young child. So for me as a physician, I was wondering if maybe the medication that he was being prescribed for ADHD, which is a stimulant, did that affect his heart in any way, because that does a lot of times. So I really couldn't tell about that. But he had said that he had also been on a Holter monitor at one point as he was older, as an adult, to sort of assess whether or not there was anything cardiac going on. He told me that he had been seeing his primary doctor to monitor his blood pressure every month, which I thought that was unusual because it's not something that you see usually somebody every month for. So it was my impression that maybe it was always problematic, and they were trying to figure out what the reason was for that. He had also told me at one point that, or maybe I asked him about it, that he had a history. Yeah, he had a history of seizures that I had read about, and I wanted to get his take on that. And he had told me that he felt that he had had grand mal seizures, and I asked him if that's what the doctors told him, or if that was just him saying that to me. And then he told me that he felt that the seizures were brought on by stress. I also noted in his records that he had seen a neurologist who had said that they were treating him for seizure, but they didn't really have any. It was mostly based upon self-report, so I was trying to figure that out, and I asked him why he never followed up with them, and he said he just financially couldn't follow up with them. Another thing that I look for in medical history is surgeries, and John did have a surgery. Aside from the spinal stimulator, he also had a right arm tendon repair, and that was due to a self-harm injury that he had done when he was 16 years old.
Did you see any evidence of any type of organic brain illness in the medical records that you reviewed?
No.
Could the defendant's reported seizure symptoms have been drug-related?
Yes, I looked at that because I wanted to find that out. He had a CT scan and an MRI done during his adult years while he was seeing Dr. Arthur. Between 2011 and 2013, Dr. Arthur actually ordered a CT of his brain, which was negative. And then he had an MRI of the brain done also, which was negative. And the neurologist, I believe, ordered an MRI also again, and that was negative of his brain. So he didn't have anything there. And then I also noted when I spoke with John about his seizures, he told me that when he was younger that they had done EEGs on him in the past, but they were all negative. And I also saw that in Dr. Arthur's records, that Dr. Arthur had noted that he had EEGs in the past, but they were negative for seizures. So that led me more so to think that these could have been drug-induced seizures, because if they were biological organic seizures, you would see that on an EEG.
What is an EEG?
An electroencephalogram.
What is that?
It's basically just a study. They put electrodes on your head, and it's basically testing for brainwave activity. And if somebody has seizure disorder, there'll be an area of seizure focus. So when they do an EEG, they'll actually do some different stimulus, things that they know causes seizures. So they'll tell you to hyperventilate, or they might do flashing lights in order to induce a seizure if they think that you have one. So that's also in that study. So there was no positive EEGs in this record.
What did you learn from the defendant about his education history?
He said that he started school late because his birthday is later. His birthday's in November, I believe. Yeah. And so he started school at the age of 6, and then he went to school through the 8th grade, went to some of 9th grade, and then quit in 9th grade. He also told me that he got held back in the 7th grade.
What did you learn from the collateral records about his education history?
Well, that...
Was it consistent?
Yeah, that was consistent. And the one thing that John told me about, because, his grades weren't bad. I didn't understand why he had gotten held back, but he told me that he had gotten placed in an AP class because his teachers thought that he needed more stimulation, he needed more challenging courses, and that he didn't really get the tutoring that he needed to be able to pass the class, and for whatever reason he couldn't get out of the class, and so that's the reason he told me that he was held back in 7th grade.
What did you learn from the defendant about his psychiatric history? What did he tell you about that?
About his personal psychiatric history, obviously at the time when I saw him, he was in the hospital. And that his doctor is Dr. Williams, and he sees him about once a month. And that he said that he's doing well on the medications, that they're all fine. And John had given me the medication names and the doses. So he didn't know his medical medications, but he knew his psychiatric ones. And then he told me about, his time with Dr. Arthur. We know that he had treatment from 2011 to 2013, but I believe he told me that he had been seeing him much earlier, from 2007 to 2013. So I asked him about that, and he didn't realize he only been seeing him for 2 years. And I asked him why did he stop, because it seemed that he abruptly stopped in December of 2013, and he said that they quit answering the phone for him. That's different than what Dr. Arthur's notes say, but that's what he thought.
What did Dr. Arthur's notes say?
That he just stopped showing up. I mean, just no show, no follow-up.
What did you learn from the collateral records about the defendant's psychiatric history beginning at a young age? And when I mean records, I'm not just referring to paper records, but also collateral sources, interviews, and collateral records.
Well, prior to seeing Dr. Arthur, so this is sort of a compilation, and I'll tell you who gave me what information, but this is a compilation of multiple different sources. John tells me that he started seeing a doctor named Dr. Nahara at USF, who's a child psychiatrist. I actually know him, so I know that that's true. And he talked to me just like how I know those clinics work. John said that he was seeing different residents while he was there, and he started seeing seeing people in treatment at the age of 5. He said that they gave him a diagnosis of ADHD, and he was on stimulant medication for that. And I believe his father also said that he was consistent with this history. And his dad said, I believe, that he was on Ritalin, and he was on clonidine. Clonidine is another medication. It's a blood pressure medication, but actually it's used a lot in people with ADHD. So he was doing that treatment, and then he stopped at about age 14 or 15. He was a teenager. He stopped treatment.
I want to talk about Dr. Arthur for a moment.
Yes.
What was Dr. Arthur treating the defendant for?
Dr. Arthur was treating him for bipolar affective disorder type 2 and generalized anxiety disorder and ADHD.
What is bipolar affective disorder type 2?
Bipolar affective type 2 is a mood disorder, and I know you guys have heard about these before. Bipolar affective disorder type 2 is a variant of bipolar disorder, and it's characterized by levels of hypomania and a major depressive disorder. So that's what that is.
Okay. And what were the primary issues that Dr. Arthur was treating the defendant for?
Dr. Arthur said in a Child Protective Service record that he was primarily...
Objection, hearsay. Hearsay within hearsay, it sounds like.
Oh,
You can answer.
he was primarily treated for anger issues. And then when you look at Dr. Arthur's records, I mean, there's multiple, it's like a regular psychiatric record. I mean, he's talking about home problems, he's talking about, problems with, his daughter's mom, he's talking about problems with his own mother. Those are typical psychiatric records. And then there are some other things in there. He talks about sometimes anxiety or problems with sleeping. There's also that one notation about the skin bubbling. There's different things in that record.
Was Dr. Arthur treating the defendant for psychosis?
No,
Okay. And why do you say that?
because he said he doesn't have psychotic symptoms.
And you mentioned that there was one notation in the file of Dr. Arthur related to skin bubbling.
Yeah.
What is that?
Well, I mean, it's a hallucination. I don't know exactly if it was a visual hallucination. I don't know if John reported that he saw skin bubbling or he felt the skin bubbling. That would be a tactile hallucination. But in any event, that was one of the symptoms that he had said at one point in time.
Could that hallucination have been drug related?
Yes, and that was one thing that I noticed in Dr. Arthur's records is that he didn't have in his differential any substance use problems. So nowhere in his records he talks about substance use problems except for at one point he had mentioned alcohol as a problem that John was going to AA, but he didn't talk about, or it didn't seem that he had any knowledge of any other substance use that John was doing, and he didn't do any toxicology screens on him that would give him some kind of reference point for that.
So you're saying he was not having him drug tested during that time period that he was treating him?
Correct, there's no drug testing in his records at all.
What did you learn from the defendant about his employment history that was relevant to your evaluation?
I was very sporadic. I mean, he would get jobs, and he actually got pretty decent jobs. At one point he was working for a health insurance company, I believe, but he couldn't maintain the job. That's mostly what he had told me.
And what did you learn from collateral sources about his employment history that was relevant to your evaluation?
Well,
Objection, relevance.
from collateral data, he did have a job. I believe that the most recent job he had was at Island Crew Restaurant where he was the chef there. But in his collateral information, it said similar things. I mean, he was working in jobs and then he just would stop showing up, or there was different reasons why he wouldn't keep the job.
Okay. So I'd like to switch gears now and talk about your diagnoses. What is a differential diagnosis? Can you explain what that is to the jury, what that term means?
Differential diagnosis, and I know you guys have heard of that also, that's basically just all the different classes of diagnoses you want to look at when you see somebody. I sort of separate them out into 5 major ones: mood, anxiety, psychotic, cognitive, and substance use disorders. And then we also have personality disorders. So those are the major categories. So when you're looking at somebody and evaluating them for mental illness, you sort of systematically go through each one of those.
And how do physicians use a differential diagnosis? Not necessarily this case, but in any medical case.
In general, we just do it because in all psychiatric diagnoses and in a lot of medical diagnoses, there's a lot of different explanations for the same types of symptoms. So you want to do a differential so that way you don't miss something that could affect their treatment.
And what does that mean to do a differential? You explained that there's 5 different categories.
Yes.
So are you eliminating?
Yes. So you go through, and I mean, every one of the categories has multiple different disorders. So if you look at, for example, mood disorders, you're looking at major depressive disorder, bipolar disorders. Those are the major ones you're looking at. But then again, there's bipolar 2, cyclothymic disorder. There's multiple different mood disorders. So you're looking at that, and then you're looking at anxiety disorders, the same thing. You go through PTSD, generalized anxiety disorder, panic disorder. You're going through the different major classes of the illnesses that are in that category. Psychotic disorders, you're going through schizophrenia, schizophreniform, schizoaffective disorder, major depressive disorder with psychotic features, bipolar affective disorder with psychotic features. So you're going through all those different ones. Substance use disorders, you're just going through just looking at all the different substance types and just asking about, tell me what substances have you used, and somebody will go through and talk to you about the different substances that they use. And then cognitive disorders, sometimes somebody will tell you that they have a cognitive disorder. Most of the time they won't, because a lot of times they don't know. So if somebody has dementia, they're not going to typically tell you that. And so they might have a complaint of just memory problems, and then you sort of go through and try to figure out what that is. And so there's different cognitive disorders. Dementia, as I said, is one, and then there's intellectual disabilities. It's a whole different category, but it's also in the same thing. So I'm going through all those different things as I'm talking to the person to sort of figure out what's their complaint, what am I seeing, and then I start ruling things out.
Can you explain your differential diagnosis process in this particular case and how you went through that?
Yes, in this particular case, it's a complicated one. And so when I went through the categories, so my first category is the mood disorder, and I didn't see any significant depressive disorder outside of just the obvious for why we're in this situation now. And then I go through just some basic questions about the mood. In this particular case, I noted that he had bipolar 2 disorder diagnosis, so I...
And who had given him that?
Dr. Arthur.
Okay.
But then as I'm doing the differential, I'm even doing the differential before I see him. So I'm doing the differential through records. And what I know biologically, bipolar disorder, as most psychiatric disorders, is a very biological illness. So bipolar disorder is affected by external things. In particular, it could be affected by your thyroid. You could have hyperthyroidism. It could precipitate a manic episode. But the one thing that I noted in this particular case is that John had been on stimulant medication since the age of 5. Well, if he had bipolar disorder, he would have flown into a manic episode with the prescription of a stimulant, because biologically, if somebody has bipolar disorder, they are going to fly into a manic episode if they have a stimulant of any type. And these are very potent ones that we prescribe. So Ritalin, any amphetamine that we prescribe. And when you treat children, you'll see that on their allergy list if they have bipolar disorder, because it'll say Ritalin or something like that, because that actually precipitated a manic episode in this child. So because of that history, I ruled out bipolar disorder, because there's no way that he could have bipolar disorder having been on stimulants for a large portion of his life, not only as a child but as an adult. So I ruled that out altogether, bipolar disorder.
Okay. And did that rule out bipolar 1 and 2 or just 1?
It rules out bipolar disorder 2 also, because it would precipitate a hypomanic episode as well. So I ruled out bipolar disorder altogether because of that.
Okay. And did
Excuse
you...
me, I'm sorry, maybe approach.
Recess till 3 o'clock, about 14 minutes. Thank you.
All right.
of the hearing in court, Your Honor.
Someone we can read my degree.
All rise. We'll recess till 3 o'clock according to the courtroom clock.
Oh, no, we're here.
Okay. I was gonna say,
Well, I'm gonna go there next, but.
I'll let you go first, and I'll go somewhere else.